start out because I'm starting from A to Z, then I'm going from Z to A, and then keep on doing it until I get it.
And you have the right to do so.
Oh yeah, because that's what I'm going to do.
Absolutely.
All right, thanks.
Thank you.
Steve.
Name and address, please.
Noble Aaron El Shabazz for Somerset, New Jersey. Just to quickly address what you said, I noticed when I came in, you were, I guess, laying down some new ground rules, and you made a statement regarding how you've been criticized with the way you conduct the meetings. So I'm just going to start off by making it clear that I believe I've said it publicly before that personally I have respect for you. I think you conduct the meetings in a pretty fair manner. So anything that I say, of course, is not personal against you. But it's directed at who it should go to. And so don't take anything I say personal, but I have some things to say that are important.
Absolutely, and I just want to make clear that when I said about the respect is that, so we had encountered some people that have they've been very disrespectful. I am open to listen to any concerns or any way of, it's just a matter of personal attacks, and that's when I have, have to put down that is not allowed anymore, because we're here to conduct business. This is the meeting of the council to conduct the business of the city of Brunswick. And part of that, as the open public partnerships of the public, is to bring concerns, and we are open to do that. But the same way that we are expected to respect and talk to the public in a respectful manner, then I think it's fair enough that we get that back without having to have. So it has nothing to say with what it says here, because I don't think none of us take it personal. It's when it goes a little bit beyond what is what you should respect with the insults and the personal attacks, and actually sometimes even verbally abusive some people. So I think we have to. So it has nothing to do. So and with you, I have never had any. I consider yourself a very eloquent and respectful. The way you conduct your duty. So I always thank you for that, because I think it shows a level of it should be modeled by others. You set an example to our community, so I thank you for that.
Thank you. Now, I'm going to move forward with my complaint. I just wanted to make sure.
I'm not going to count those minutes, okay?
Thank you.
I start you at 5.
All right. To address this liaison process, the whole process is flawed. And I'm going to point out how the whole process is flawed in some general ways. One, the liaison and hearing officer violate their own protocols whenever they feel like it. I demonstrated that the last time I was here. I sent letters in to the council outlining the protocols that they violated, and sent a copy of the very protocols that they gave me that they stamped as an exhibit. So I've already proven that they violate the protocols. Also, there are clear conflicts of interest with the city attorney having the community liaison position. One, the city attorney is an adversary who prosecutes the people, while a community liaison acts more as an advocate that assists, or supposed to assist the people with dealing with internal affairs complaints. So you can't have someone be on the side of the city in an adversarial position as a city attorney whose job it is to prosecute people on a regular basis. That's what Ms. Gayton does. And then turn around and expect the people to believe that she's an advocate for them who's going to help them proceed with complaints against city police officers when these are her colleagues. That doesn't even make sense. It's obvious that there's a clear conflict of interest. Also, it's a conflict to have public hearings in her private law firm office. Ms. Gayton is also a private practicing attorney. She has the hearings that I had to have in her law office, and then arbitrarily makes up whatever rules she wants to make up because it's in her office. That's a conflict, clear. So when I point out certain things, there's no way anyone can argue against it. If they do, it would be a frivolous argument and an illogical argument. Who cannot see that? That's a conflict. If I come into your private office where you then impose your own personal rules, that's a conflict when you're supposed to be my advocate. She attempted to actually say that I couldn't bring people to witness the proceedings initially when I first requested to do that, because I didn't trust her and I didn't trust the hearing officer. So she tried to tell me I couldn't do that. She actually lied to me and told me, well, Mr. Shabazz, the protocol's prohibited. If you would have read the protocols, you would know that they're prohibited. And I said, well, actually, ma'am, I did read the protocols, and they do not prohibit it. I said, in fact, it makes no mention of whether you can or cannot bring people to witness the proceedings. So while you may claim it doesn't permit it, it doesn't prohibit it either. And since this is an informal hearing and there are no formal restrictions, then if I want to exercise my right to bring people to witness the proceeding, why is that a problem? It's not a secret tribunal. She was like, well, you're right, it's not a secret tribunal, but I don't think, well, wait a minute. You just said if I read the protocols, and I explained to her I read the protocols and it's not in them. Once I basically forced the issue, she said, well, I'll call Judge Hoffman and see what he thinks of it. And ultimately, they allowed me to bring witnesses, but it's only I have to fight for everything I got. She never acted as an advocate. She was always adversarial from day one. So how is there not a conflict? We're having meetings, we're having a hearing in her private office where she tries to dictate what the rules and regulations are. She violates the protocols. How is there not a conflict? Also, to further demonstrate that there is a conflict, recently I had a parking ticket matter in New Brunswick Municipal Court before Magistrate Philip Burr. While me and my queen were sitting at the court waiting in the hallway, City Attorney Charlie Gaydon walked into the courthouse. She walked in, went into the prosecutor's office, and waited for Magistrate Burrow to enter. When he entered, she came out, greeted him, hugged him, kissed him on the cheek, and then they went to the prosecutor's office. They were in there for about 20, 25 minutes. Finally, Magistrate Burrow takes the bench, and ultimately, he says to me, Mr. Shabazz, I was just informed that you filed a civil lawsuit against the city, and since you filed a federal lawsuit against the city, there is a conflict of interest and I cannot hear this case. These are his words on the record. He said, in fact, no New Brunswick judge can hear this case because there would be a conflict. Any New Brunswick judge is an agent of the city and therefore a conflict automatically exists. They would automatically be presumed to have a bias against me because I have a lawsuit against the city. Now, if anybody understands conflict of interest, that same conflict should be attached to City Attorney Gaydon. The same way that magistrate can't hear, or no magistrate, not even just Mr. Burrow, no magistrate from New Brunswick can hear. He said either they would have to transfer my case to another town, to another municipal court in another town where no conflict exists, or they would have to have a visiting judge come into New Brunswick where this judge is from outside of New Brunswick jurisdiction and would then come in and hear the hearing. And he said, if they decide to do that, they'll send me a notice letting me know that that's what's going to happen. Now,
Mr. Shabazz, I'm sorry to
yes, ma'am.
interrupt you. It's more than 5 minutes. But this council agreed to give a few minutes to Mr. Shabazz.
Well, I have one question, Mr. Hamilton. Did you say you have a lawsuit against the city of New Brunswick? A civil lawsuit against the city?
Yes, sir.
Does that intend us from speaking with you?
I don't think you ought to discuss it with him. It doesn't prevent him from speaking in council meeting.
He could talk, but we don't.
Okay.
So, go ahead, Mr. Shabazz.
Thank you. And I mean, that's not a problem because, I mean, for the most part, nobody from the council ever speaks to me anyway, so it's business as usual. But my point is, the magistrate said there was a conflict of interest and no New Brunswick municipal judge can hear the case against me because they recognize the conflict. All of those judges are agents of the city. No agent of the city can then be involved with my case because of the conflict. Now, if Ms. Gaydon is a city attorney who prosecutes the people when they come to court, how can she then turn around and not be considered an agent of the city when she's so supposedly acting as a liaison and supposed to be assisting people in filing complaints against other city agents, namely police officers. That's a clear conflict of interest. I don't understand how anyone can pretend that it's not. Well, I do understand how people can pretend, but the reality is it's not. Also, let me make sure I didn't skip it. Also, at the hearing, City Attorney Ms. Gayden cross-examined. I believe at the last City Council meeting I was at, Mr. Kratovil testified or expressed that while he was at the microphone that the hearing was a sham, and that the hearing officer, Mr. Hoffman, actually said to Ms. Gayden, to City Attorney Gayden, she shouldn't even be referred to as a community liaison, and I will never refer to her as that again. She is a city attorney. That's her true position. And he said that City Attorney Gayden, hearing officer Hoffman said to City Attorney Gayden, do you want to cross-examine the witness now? That's an adversarial position. She was acting as a city attorney, cross-examining the witness. In their own words. No way around it. So there's clearly a conflict, and she should not be allowed to be the city liaison, the community liaison, and you can't expect anyone here to trust her and believe or have any confidence that we're going to get treated fairly, and the process has been proven not to be fair. Also, to further prove conflicts of interest, when we would meet at her office, as we had numerous meetings at her office, when I was trying to get, for the year and a half that I was trying to get a hearing even scheduled, she would constantly cancel the meetings, and I've already expressed that before. But what I would also like to express is, when we would have these meetings, we would sometimes sit in her office for 30 to 40 minutes. We're not discussing for 30 and 40 minutes what day is best to schedule a hearing. No, she's asking me questions about my lawsuit. She's telling me that Jennifer Passanante, which is the attorney that's defending the city now against my lawsuit, she would tell me that that attorney is emailing her, telling her about the case. And then she would ask me questions about the case. You can't ask me questions about the case, communicate with the other attorney that's an adversary against me, but tell me you're not an adversary also. She's clearly acting as a city attorney while pretending to be a community liaison, questioning me, trying to get information out of me, and I have the proof to support what I'm saying. So if anybody doubts what I'm saying, I can bring you the proof and demonstrate to everyone here that she would ask me lengthy questions about the lawsuit, including questions about a motion to challenge lack of jurisdiction, a motion to get the case dismissed. She went to lengthy discussions with me about the lawsuit. Now, if she's acting as a community liaison, why aren't we talking about scheduling the hearing, and why did it take so long, almost 2 years, to get a hearing? But yet, it's because she's too busy acting as the city attorney and trying to sabotage my case. The hearing officer made decisions based on facts not in evidence, which is improper and unfair. And as an ex-judge, he knows very well that a hearing officer is not supposed to make his decision, his or her decision, based on facts not in evidence. They can only make their decision based on the facts that are in evidence. The hearing officer raised the legal standard from only a preponderance of evidence standard, which is a pretty easy burden to meet. That's only really technically 51%. I have to prove that what I'm saying is 51% more likely to have happened than not. That's an easy standard to meet, especially when I'm presenting audio dispatch records and trial transcripts where the officer's testimony is in conflict with the audio dispatch records. Yet, he raised the standard in order to show favoritism to the officers and rule in favor of the officers and deny me getting the recommendation to reopen the internal affairs investigation. And basically his decision was very illogical. Yet the rules, the Attorney General guidelines for internal affairs states that they're supposed to review the evidence and make a decision based on logical conclusions. His decisions were not logical. To further go into the illogical conclusions, the hearing officer said he found it somewhat troubling that the initial arrest report with Officer Gregas, Officer Brant J. Gregas, and Officer Daniel Maison. Initially, when I went to trial, they had an arrest report against me. That arrest report was introduced into evidence and stamped exhibit whatever, A, B, whatever it was. This very stamp is in the section that says narrative. Now we know it is common policy and procedure of police officers that when they arrest someone, they do a narrative. They're supposed to do a narrative on what took place during the arrest. The narrative section is completely blank. The only thing there is that stamp from the court saying exhibit. I introduced that as evidence proving they were lying, because if I had done all the things they said, surely they would have typed it up in a narrative. They didn't type anything because I never did anything wrong. Now, I knew that these officers are corrupt, so a year and a half later, I decided to type up a common law request for another police report for that situation. Figuring that they would probably, now because I have the lawsuit in effect, I figured they probably would create one. Just as I anticipated, I get back another police report, and now all of a sudden there's a typed up narrative that basically repeats what they said at trial. The hearing officer himself says that was troubling to him, to see one arrest report with no narrative and another arrest report with a narrative. Especially when I had it marked, stamped in evidence, so there's no way they can deny that it's not the original, truthful arrest report. He further says that he suggests further inquiry be made into preparation of the report. Now, since he denied me a recommendation to have Internal Affairs reopen the investigation, my logical question is, who's supposed to make further inquiry? He says it's troubling about the reports, the two conflicting reports. And he says further inquiry should be made into the preparation of the report. But he denied my recommendation for Internal Affairs to reopen. So if Internal Affairs is the people that's supposed to investigate crooked-looking things, possible crimes, because that's called tampering with government records, that's a felony. So therefore, if Internal Affairs is not going to investigate it, who is he suggesting make further inquiry? His decisions are completely contradictory and illogical, make no sense whatsoever. He goes on to say, dealing with the second incident I had with Officer Brad Burdell and Rodney Chang, that they claim that I was impeding the flow of traffic when we're in a big giant parking lot at 1 in the morning and there's no traffic back there, it's just me. And then they pull back. They say I'm impeding the flow of traffic, and that was their probable cause for stopping me before they call for backup and 10 officers show up and they snatch me and my friend out of the car and illegally search for 32, 33 minutes. He sees the proof and knows that I'm telling the truth, so what does he say in order to show favoritism to the officers again? Theoretically, I was blocking traffic. Now, he's an ex-judge again, so I'm demonstrating the corruption that's going on here. He's an ex-judge. He says, theoretically, I was impeding the flow of traffic. How do you theoretically, once again, I have a logical question. How do you theoretically block traffic? What is this? Some imaginary blocking of traffic going on? Theoretically, I'm imaginary, in an imaginary way I'm blocking traffic. But we're dealing with an ex-judge, so he knows better. So this is clearly corruption. He's biased and prejudiced in favor of the officers. Because statutes are literal, not theoretical. And as an ex-judge, hearing officer knows full well that The impeding statute falls under the literal or plain meaning rule, which dictates that statutes are read word for word and interpreted in ordinary language meaning, ordinary based common sense meanings, because theorizing is equivalent to making law. So these officers would be making up the law, as my queen said earlier. They make up the law as they go along, and he's giving them permission and justifying them making up laws. In theory, I was blocking traffic, so I'm not really blocking traffic, but in theory, they can charge me with it because they can make up whatever laws they want on the spot. They're not the Congress. They have no power to legislate. They can't make laws. They only are authorized to follow the statutes that's on the book, and they have to follow them the way they are written and read. They can't make up, they're not licensed to practice law. Every time I cross-examined them at trial, the prosecutor, the municipal prosecutor, constantly yelled out objection beyond the scope. He's asking the police questions beyond their scope. And the magistrate would sustain that objection and state that, Mr. Shabazz, you can't ask them those type of questions. They're not lawyers. They don't know the answers to the questions you're asking, and they're not required to know because they're not lawyers. You're asking questions only lawyers should know.
Mr. Shabazz, to be fair to everybody else, 3 more minutes.
Okay, yes, ma'am.
Thank you.
I would just like to also state, I'm not a lawyer, but I knew the answers to the question. So, once again, Elijah. The hearing officer accepted as fact that Officer Chang saw my friend Mr. L move his hand behind his back. My logical question is, how did he determine this to be a fact when Officer Chang never testified or made any statement about on the record about the facts? Only Officer Brad Bedell testified that Chang allegedly said this, but that's hearsay. And hearsay from a disgraced cop who was forced to resign and found guilty of 3 departmental violations. And even the hearing officer states in his report that Bedell's testimony in my trial was troubling. He was an evasive witness, and many answers from Bedell were in conflict with dispatch records. This is what the hearing officer said in his own report. So the officer has no credibility, and since Officer Bedell's testimony is the only testimony in record, how does he find that my friend was hiding some bottle of pills behind his back? And how does he find, he goes on to say that the search against me was a legal search. He said the officers had the right to search. Yet Brad Bedell's the only one who testified. Again, Chang never testified. And Brad Bedell said no search ever took place, that they never searched. So once again, how is the hearing officer deciding that if there was a legal search when the officer testified no search ever took place? Where's he getting this information from? He mischaracterized the situation and made it sound like my friend had some illicit drugs. My friend had a bottle with 5 high blood pressure pills in it. Pills that you can look up online and will tell you they're Mylan. It says they're for diabetes and high blood pressure. He explained to the officers the pills were from his girlfriend or his children's mother, and they were together earlier, and she put it in his black carry bag. He had a private black carry bag. I mean, they committed a legal search anyway. He never had no pills in his hand behind his back. They opened up his bag, dumped it out when they illegally searched, and snatched us out the car. But either way, why would my friend need to try to hide blood pressure pills? So once again, these are illogical conclusions that this hearing officer is making. The whole process is flawed because everyone involved in IA investigations and reviews deliberately become scarecrows from the Wizard of Oz, where they conveniently lose the capacity to follow all evidence to its most logical conclusions and start singing the scarecrow's famous song, "If I Only Had a Brain." That's what they do. They lose their common sense. They lose their brains when it's time to make logical decisions about crooked police officers. And then we're the ones left to suffer. It's not right. With all these flaws, there also needs to be an appeal process to be able to challenge the hearing officer's illogical conclusion. That's what you need to set up. The council has the power to do this, and I am respectfully requesting that you set up an appeal process so that when people like me come and can show you how illogical the conclusions are, there should be something that we can do about this. You should be able to take remedial action to remedy this situation. Also, I was advised that Officer Brant J. Grigas, who committed these serious misconduct acts against me, as well against my comrade Tim McDougal, where he violated his rights and illegally searched him and then planted marijuana on him, and they ultimately dismissed the charges. He had 2 eyewitnesses that were ready to testify for him. Internal Affairs didn't even interview his witnesses. Those are clear violations. They say they conducted a proper investigation. If you don't interview 2 eyewitnesses, how are you conducting a proper investigation? Yet, I know he's going, because I'm going to continue to encourage him to also pursue this sham. If not only just to prove further that it is a sham, because I'm sure he's going to get the same results I got. The hearing officers are going to rule against him and in favor of the officers, and he's not going to get any justice. But from my understanding, Brant J. Grigas has been promoted to a detective. So he gets complaints, serious complaints, evidence to support the complaints, but everyone covers for him and then promotes him. Okay, I'll just end with this. Since he was promoted, what message do you think that sends to the people? The message that is sent to the people is that the whole administration is corrupt, and we cannot get justice from a crooked and corrupt administration. And that causes one thing: people to feel desperate and hopeless. And when people feel desperate and hopeless and feel like they can't get justice from the people that are supposed to ensure that they get justice, people will feel they only have one last resort. And they will take justice into their own hands. At this point, if the city would have done what they were supposed to do and disciplined Officer Brad Bedell and all the other officers I named, Brother Barry DeLoach would still be alive. So as far as I'm concerned, the city has blood on their hands, because if they would have... Barry DeLoach was shot 6 months after I filed my complaint, after I was violated. So I just want to make that clear. You need to think about what you're getting ready to do as a council. He was shot 6 months later. If they would have done the right thing and Internal Affairs would have disciplined him, he would have been deterred from doing what he did to Barry DeLoach. But since they basically showed tacit approval of his misconduct, he went on to now shoot a man in cold blood and then cover it up. So the city has blood on its hands, and if the city does not heed my warning, I'm warning you that you have officers now, and all of these officers are liabilities, because with the complaints you have against them, yet you still allow them to stay on the force, then that means anybody they violate from here on, how are you going to be able to justify that?
Thank you, Mr. Shabazz. Thank you.
Good evening, members of the council. I'll try to be quick with respect to the new rules. My name is Charles Kratovil.
I wasn't following.
The old rules. Well, maybe you could change them. That would be nice. I want to bring up the situation that was just talked about. That is something that's very